Court is calling 2025 CR 0074009, State versus Patrick Keith Thomas. Can I have parties announced?
Jason Gary, for the state, Your Honor.
James Starkey for Mr. Thomas.
And are you Mr. Thomas?
Yes, ma'am.
Counsel, is there an application?
No, ma'am.
All right. Counsel, have you received all discovery? Did you review it with your client?
I did.
Court will find that the state is in compliance with discovery. Mr. Thomas, did you review the true bill of indictment with your attorney?
Yes, ma'am.
Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Judge.
State, are you proceeding on the indictment as presented?
We are, Your Honor.
Did you review the admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with theft with 2 or more previous convictions as a state jail felony? Range of...
Notice how the judge lays out the punishment range? 180 days to 2 years? That's not just formality. It's a legal safeguard, making sure the defendant can't later claim they didn't know what they were signing up for.
Punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I believe he does.
Mr. Thomas, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 180 days in the state jail facility, and there are no applications. Did you understand?
So right here, 180 days, locked in, no wiggle room. Think about that. Just 6 months, but in a state jail. Do you think that's a slap on the wrist for theft? Or is that already a harsh...
Understand that to be the plea?
Yes, ma'am.
Defense?
Yes, Judge.
State?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Judge.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
Yes, Your Honor. State Exhibit number 1 with all of its attachments.
Without objections, Judge.
All right, state, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments and review the same.
Yeah.
All right, after reviewing State's Exhibits 1 and attachments, the court will find...
And there it is, the official guilty ruling. Notice how quickly that happened? No witnesses, no dramatic testimony, just paperwork and stipulations. For anyone imagining long trials like on TV, this is the reality.
There's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
We're ready, Judge.
Anything you wish to say on behalf of your client?
No, ma'am, at all. We're obviously just asking the court to honor the agreement.
All right, the court will sentence you to 180 days in the state jail facility, give you credit for any time served, and there's to be no contact with Walmart. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
All right, because this is plea bargain agreement, because I followed your plea bargain agreement, because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, so we can go off the record. Here's the thing. If you don't stop doing this, you're going to end up in and out of jail. You understand? And out of prison.
Only thing I can say, Your Honor, is do it.
Yeah. So
I don't have
That's raw honesty. No excuses, no alibis, just calling his own actions stupid. But here's the tragedy. Even when people know it's reckless, some can't stop the cycle. What do you think?
Excuse for myself.
Yeah.
It's really stupid.
Well, I mean, you have to figure out why you're doing what you're doing and stop it, okay? Because otherwise it's not going to end good. And at some point, these state jail felonies, the range of punishment becomes 2 to 20. All right?
Yes, ma'am.
So if it's a homeless issue, there are plenty of places to stay. If it's a compulsion issue, there are plenty of places you can get help. You understand?
Yes, ma'am.
All right, good luck to you, sir.
Thank you.
You're welcome. Who is here on Raymond Francis Haynes?
Morning, Your Honor.
Good morning.
Does Mr. Haynes need to come forward, Your Honor?
Yes.
800. Thank you. Park the red seat over there.
Hard to get people up here.
Oh, it is. People don't want to come. But you know, I've discovered during jury trials, people don't want to leave. Jurors want to leave, but then they don't want to leave. All right, where are we on discovery?
Judge, I think discovery is complete.
I believe discovery is complete.
Yeah, as far as I know, Judge.
All right, so I need an acknowledgement of discovery before you leave. And was an offer tendered today?
No, Judge, defense counsel can explain that.
Yeah, not yet, Your Honor. We would like to have Mr. Haynes. He's 100% disabled for a veteran, and we would like to have him evaluated for VTC. I guess I'm not. I think that after that, if he's eligible, then we get an offer. But that's. I think that's the route we would like to go down as of now.
Vashon, do you have any idea how long it would take VTC to review him? Right. So just have a seat. They're going to call VTC and see how long this will take, and then I'll give you a date.
Thank you.
You're welcome. Who is here on Robert James Kianis? No, I have Matthew Dotson, Martinez, and Haynes. All right, Mr. Kianis, come up. All right, so in this case, where are we on discovery, counsel?
Your Honor, I just confirm with Duffy, it appears that we have everything. We're just asking for a short recess so we can go through it all and confirm that we're not missing anything. If the court would let us come back in 2 weeks, just so we have time to make sure we aren't missing any additional discovery.
All right, Norma, if I can get a 2-week reset for discovery, please. All right, we'll bring you back on August 21st for discovery. It's to make sure that your attorney has all of the information that the state has. Do you have any questions about anything?
I would just like to raise a timely objection to the Texas being abstract subject.
Whoa, curveball. The defendant just threw in a subject matter jurisdiction objection. That's usually civil court talk, not criminal. Judges hear these sovereign citizen type arguments a lot. It
Matter jurisdiction, and I'm not waiving the right to the defect.
All right, so you're saying subject matter jurisdiction? All right, so usually when you're speaking of subject matter jurisdiction, no, I hear your objection. Usually when you're speaking of subject matter jurisdiction, that's usually on the civil side. So what I can tell you about subject matter jurisdiction in this court, and I think I know what you're trying to say. So you're charged with a felony. So this court presides over felony cases. So based upon your indictment, which is a felony indictment for aggravated assault with a deadly weapon and unlawfully carrying a weapon with a felony conviction, those are all felony offenses under the penal code. So you are in the correct court. So the subject of your indictment is what the type of cases this court handles.
and I'm gonna be able to have a trial, right?
If you, I can't give you any advice, but your attorney is here to assist you. And if you want a jury trial, of course, the court will give you a jury trial. But what I usually do in the process in this court is I want to make sure that your attorney has all of the discovery, which means he has everything that the state has. And if he thinks there's something the state doesn't have that he should have, he's entitled to have that. And then once he tells me he has all his discovery, then I will set this for a plea deadline date because I require that the state tender an offer to you. You can discuss that with your attorney. If you decide not to reach an agreement with the state, then the next course will be a jury trial. All right? All right, thank you, sir. Have a good one. All right, so where is he? Come forward, please. All right, can you raise your hand? You solemnly swear and affirm all this true and correct will include your personal knowledge. All right, if you'll fill that out, and then I'll take it up. All right, Larry Morris, Matthew Luis Martinez. Just let me sign this.
Every once in a while, I have to sign those too. I don't do it from the district judge, I do it from the justice of the peace.
Hey, it's still needed. All right, thank you. Have a good one. All right, court is calling 2025 CR 05084 State versus Matthew Luis Martinez. Can I have parties announced?
Ashley Jones for the state.
Tommy Ramirez representing Matthew Martinez, Your Honor, will present read.
All right, and are you Matthew Martinez? I'm going to need you to speak up so I can hear, okay?
Your Honor.
And the court reporter. Counsel, have you received all of the discovery in this case and did you review it with your client?
I did, Your Honor, in my office.
Court will find that the state is in compliance with discovery. Mr. Martinez, did you review the application for deferred adjudication with your attorney?
Yes, sir.
Did you understand it?
Yeah.
And did you sign it?
Yes, Your Honor.
Did you review the true bill of indictment with your attorney?
Yes.
Did you understand it?
Yes.
Just one moment. Do y'all have the indictment on Martinez?
I actually have an extra copy, Your Honor.
All right, thank you. Thank you. Did you review the true bill of indictment with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
I do, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
All right, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
Did you understand you're charged with burglary of a habitation? That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand by entering this plea you were giving up those rights?
Yes.
And did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able, is he applying for deferred adjudication as well?
He is, Your Honor.
All right, did you understand that the court would grant your application for deferred adjudication if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in prison and up to a $10,000 fine?
Yes.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor. We've been able to discuss it at length.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do believe he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Martinez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
Anyone promise you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes.
According to the plea, punishment is to be assessed at 3 years in the prison. There's a $1,500 fine. The state is opposed to your application for community supervision and deferred adjudication, and there's to be no contact with the complainant. Did you understand that to be the plea?
Yes.
Defense?
Yes, Your Honor. That is our understanding.
State?
Yes, Your Honor, that is our understanding.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes.
Did you understand by signing that you're waiving your right to appeal, The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, have there been any such motions?
Not to my knowledge, Your Honor, but I'm not the court-appointed lawyer who was here before me, but my understanding in reviewing the file, there are none.
Thank you. And then, Mr. Martinez, to the offense, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State, any evidence?
The state would offer State's Exhibit 1 and all attachments.
No objection.
All right, State, you may be excused.
Thank you, Judge.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments and review the same. After reviewing State's Exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. We can go off the record. So a PSI takes about 8 to 12 weeks. So we can reset this for 8 to 12 weeks for a PSI and TAP evaluation, or if you would like, I can have this recalled back in a shorter time and you can bring whatever witnesses you want to bring. And I do ask that the state bring the criminal history.
Your Honor, I think we can probably come back sooner with a couple of witnesses. My client has been recently released from a prison sentence on a revoked probation. He has taken steps, has found meaningful employment, which is difficult for a felon. He has already made arrangements with the state of Texas to get his driver's license reinstated and has an appointment for that to be done on August 28th. Once that is done, his employment will become full-time and permanent. He has also made arrangements so that he will not have any contact, and this was before this arrangement today. As soon as he got out, he made arrangements so he would not have contact with the mother of his 2 children, and he has been having his mom be the one that picks up and drops off so that mom doesn't feel threatened in any way. So my client is taking significant steps to try and get that done, and we can present some testimony on that when we come back a little bit sooner.
All right. So then what we will do is, Ms. Ferguson, if I could have a reset date on this for 3 weeks, and if you want to, or do you want it, if you want it sooner, just let us know.
I'd like it, if we can, Your Honor, that first or second week of September. That way he would have already obtained his license by then.
All right, so it can't be the first week in September because I have a judicial conference. So
The second week.
all right, Ms. Ferguson, what date?
Yeah, Monday works best. I have a docket I have to call on Tuesdays.
All right, thank you. Once you sign the reset form, you are excused.
Thank you, Judge. We appreciate your patience.
All right, thank you. No, there's no PSI. Hi. Oh, come on up. How are you doing? Great. Let me just put this in here. Oh, and if you'll have your client come up.
Yes.
Thank you. Who's this? All right, so when can you all get a
So I
evaluation?
was speaking with Bashan, Your Honor, as well as Mr. Hilliard. So good news, bad news is we have a lot of referrals that are popping right now. So we're full transparency to you in the court. If we have 45 days, I can guarantee done, assessed, staffed, and an answer back to the court. As long as Mr. Haynes gives us everything according to as quickly as he has it, there's an open slot for assessment. We'll fill him in there, and we may be able to get back sooner.
All right, so this is what's going to happen. I'm going to give you a 45-day reset. That's all you all will have for this. After that, so in 45 days, that's going to be your plea deadline date on that date as well. So everything should be done by then.
Yes, ma'am.
All right, Ms. Ferguson, I need a 45-day reset, please. All right, September 22nd. Once you sign the reset form, you're excused. All right, thank you. You're welcome.
If we get it done sooner, Your Honor, we'll make sure to let the court know.
Okay, if it's done sooner, just let council know and we'll bring him back sooner.
Thank you so much, ma'am.
All right, thank you. All right, just give me a moment. All right, Larry Morris. Come forward, sir.
It's got a nicer suit on than I do.
Mr. Morris, thank you for dressing appropriately for court. You always do, though. I really do appreciate that.
You're welcome.
All right, so we're back here today. Where are we on discovery, counsel?
Your Honor, we have gotten complete discovery.
All right, state on Larry Morris, I'll need a discovery acknowledgement.
Yes, Judge.
And were you able to get a plea?
Judge,
An offer tender?
we got an offer. It involves upfront restitution. And the DA has given me 45 days, if that's okay with you, to get that together.
All right, Norma, can you recall this also on September 22nd? All right, so September 22nd is going to be your plea deadline date.
Okay.
Once you sign the reset form, you're excused. And once you sign the acknowledgement of discovery, you'll be excused.
Thanks, Judge.
All right, thank you.
All right, have a good day.
Thank you, you too.
I'm starting back up this afternoon.
Yes, at 1:30.
I was watching you yesterday.
We'll see the way that it goes. People always think that I know what a case is about. And I said, nobody just gives me anything
You
beforehand.
don't want to know.
No, don't want to know.